Buenos días. Mi nombre es Amelia Alba y les doy la bienvenida a la sesión 10 titulada, a ver, em, Cortes Culturales y Derecho Constitucional. Para mí es un placer estar nuevamente en el EMPI. Es un proyecto que se inició hace más de una década y estoy muy contenta de que está incorporando a nuevos investigadores que están además en el camino del doctorado. Entonces, espero que esta sesión pueda servirles a ustedes para obtener algunas posiciones interesantes, comentarios que puedan enriquecer sus estudios. Voy a hablar un poco despacio por consideración a los intérpretes. Entonces, también voy a explicar, estamos con un retraso de casi 15 minutos. Ya con anterioridad, los miembros de la mesa habían recibido, ¿no? Las indicaciones del tiempo. Entonces, yo les había dicho que cada speaker iba a tener 20 minutos y la discusión iba a tener unos 15 minutos e íbamos a dejar 10 minutos de interacción con el público para preguntas y respuestas. Entonces, procedo yo a presentar a cada una de las ponentes sin tomarme más tiempo. La primera persona que va a presentar la ponencia es Victoria da Rosa Silva da Cal. Ahora voy a hablarlo en inglés porque tengo de este modo, en esta versión, la hoja de vida o el resumen de ello. She's a lawyer enrolled in the Master of Social Sciences, Cooperation and Development in Latin America at the Sorbonne Nouvelle. The title of her presentation is Legal Pluralism in Brazil, Analyzing Emblematic Cases of Indigenous Justice. Her paper explores legal pluralism, indigenous rights, and criminal justice, focusing on how Brazil's legal system interacts with indigenous communities. The research investigates the gap between Brazil's legal framework and the practical judicial processes involving indigenous people, highlighting the systemic failure to recognize and appropriately treat indigenous identities and legal customs within the criminal justice system. En segundo lugar, tenemos la exposición, la presentación de Tuyara Tumusova. She is from the Sakha-Yakutia Republic Russian Federation. She studies at the Northeastern Federal University. She obtained her master degree in theory and analysis of law at Paris-Nanterre University. In 2023, defended her doctoral thesis in public law at the same university. Her interest topic was legal identity of indigenous people in Russian law, the case of the Sakha Republic Yakutia. The title of her presentation in the session of today is The Challenges of Interpreting the Rights of Indigenous People in Russia, the Constitutional Court's Approach. Her paper is based on the results of the critical analysis of the jurisprudence on the interpretation of the rights of indigenous people in the Russian Federation. In particular, the paper examines the issue of the protection of the rights of indigenous people in Russia by constitutional justice, focusing on two judgments of the Constitutional Court of the Russian Federation, Chakin and Danilov. Mariana Monteiro Matos, she's coming I suppose in 20 minutes when she was indicated. She's a postdoc in Portugal, in Lisbon. She's a research fellow and lecturer at the postgraduate program in law of the Federal University of Pará in Brazil, and a research associate of the Department of Law and Anthropology of the Max Planck Institute for Social Anthropology in Germany. Her interdisciplinary research combines doctrinal and empirical methods, focusing on human rights and diversity and in the context of minorities and indigenous people. Her latest monograph, Indigenous Lands Rights in the Inter-American System, Substantive and Procedural Law, was published by Brill in 2021. Well, the title of her presentation is The Multiple Roles of Socio-Anthropological Expertise in the Adjudication of Environmental Rights in the Inter-American System, Indigenous Land Claims and the Shukuru People Case. And in the last part, we have the discussion. It's Sara Imani. She's a German qualified lawyer and since 2024, a research fellow and policy advisor at the Deutschen Institute for Menschenrechte. Her areas of expertise are international law, international criminal law, human rights law, and international legal theory. She worked in these areas as researcher and lecturer for various universities before joining the Deutsches Institut for Menschenrechte. She worked as legal advisor at European Center for Constitutional and Human Rights, where she was responsible for its work on German and European colonial crimes, reparation, and restitution. Bueno, entonces, sin mayor preámbulo, voy a dar el uso de la palabra a la primera speaker, quien es Victoria. Por favor, Victoria, te escuchamos. Tienes 20 minutos.
Thank you for the PowerPoint.
To be?
Yeah, I sent you.
To my WhatsApp?
Yeah.
Okay. Sorry, I will take a few minutes. Va a tomar algunos minutos. Victoria, ¿cierto?
Yeah.
Ya puedes empezar. Sí.
Okay. Okay, so good morning, everyone. My name is Victoria, and I'm here to present my research on legal pluralism in Brazil, analyzing emblematic cases of indigenous justice. I began this research when I was in graduation and in the law school in Brazil. And the scope and objectives of my study is to delve into the intersection of Brazil's legal system and the rights of indigenous communities, focusing specifically on how criminal justice process handle indigenous identities and legal customs. By examining 4 emblematic cases, the study highlights the systematic failures and proposes the necessity for the colonial approach to justice. The disciplines involved in this study is primarily legal pluralism, which refers to the coexistence of multiple legal systems within given jurisdiction. And this research thesis aims to investigate the discrepancy between Brazil's legal framework and the actual judicial process involving indigenous peoples. Despite constitutional guarantees and international agreements, there's a significant gap in the practical application of these laws. And the central question driving this research is, how does our system fail to adequately address the rights and identities of indigenous peoples within its criminal justice process, and what are the implications of this failure for indigenous communities? The approaches I use theoretically, it's the critique study of the assimilationist policies embedded in Brazil's legal codes. And empirically, I examine specific legal cases and especially the implementation of a resolution, the resolution number 287 by the National Council of Justice in 2019, which is the newest law we have concerning rights of indigenous peoples within the judicial process. And this resolution, yeah, you can That's it.
Espera, perdón,
Okay.
tengo que compartir.
Go. 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 And go. Okay, yeah, that's it. Thank you. This resolution guarantees some specific rights for Indigenous people. These include the requirements that procedural records be forwarded to the nearest FUNAI office. FUNAI office is the foundation of indigenous peoples in Brazil, and it's responsible to defend their rights and promote their guarantees to the market indigenous land. Anyway, and so this process have to be forwarded to the FUNAI within 48 hours of an arrest, and the inclusion of search information in the judiciary's data system, and the right to interpreters, preferably from the same indigenous community as the defendants, to be presented throughout the judicial process. Besides that, it further stipulates that judges should, whenever possible, order an anthropological examination upon receiving a report or complaint against indigenous individual. This examination aims to provide necessary elements to determine criminal liability, thus preventing discriminatory and arbitrary decisions based on ethnocentric judgments. The anthropological report should detail the defendant's ethnicity, native language, cultural, social, and economic circumstances, customs, and how the community interprets the allied conduct. Additionally, it should explore whether there are any alternative resolutions within the individual's native community. The resolution encourages judges to apply indigenous conflict resolution methods, and if a sentence involving deprivation of liberty is inevitable, to collaborate with FUNAI, the agency, and other institutions to implement a special semi-free sentencing regime that respects the convicted person's ethnicity. House arrest is also promoted with the individual's home defined as the territory of their community following prior consultation. There is a significant, although there is a significant contradiction within the resolution, which invokes the convention of the International Labour Organization Convention on Indigenous Peoples, number 169, stating that indigenous peoples should be consulted in the issuance of norms affecting their interests. And however, the council itself did not involve indigenous organization in the development of this resolution. So the four cases that that is emblematic in this study, it's the Basilio case, the Denison case, the Indigenous jury of Roraima, and the newest case that happened in Altamira in Pará, that is an ongoing case. So the first one, it happened in 1986 and involved a homicide within the Makushi community, and Basilio, the author, was punished by the community through exile. When the case reached the official courts, it was dismissed based on the principle of non bis in idem, which prevents double jeopardy. This is the first case to exemplify the conflict between state law and indigenous legal practice. Another significant case is the Denison case from 2012. And here the judicial decision was based on a combination for the first time of the federal constitution and the International Labour Organization Convention and the Statute of the Indian. Our federal constitution is from 1988. And it's inscribed in the cycle of the new Latin American constitutionalism. And although it is not as detailed as the Ecuador or the Bolivian constitution on the indigenous rights and these communities, it has an article or several articles that treat the rights and guarantees of indigenous communities. And this case set a precedent for how the state and indigenous legal system can coordinate, highlighting the potential and limitations of legal pluralism in practice. It is stated that when both parties are indigenous and an incident occurs on indigenous land without community judgment, the state intervenes in a subsidiary manner. Otherwise, when there is community judgment, the state does not intervene. The third case, the Indigenous Jury of Raymond, established in 2015, was set up within the Raposa Serra do Sol indigenous land, and it was set because there was no community punishment after a tentative of homicide involving two brothers accused to attack another indigenous individual. In this case, a state legal response was still required, as demanded the precedent created in the previous case, and this jury with exclusively indigenous jurors was set. However, despite attempts to democratize the process, it operated within the colonial shackles of state law, leading to significant criticism from indigenous leaders. And this case opened the door for indigenous mobilization and the formulation of internal trials, highlighting the tension between the state procedures and indigenous justice. The last case, the ongoing case in Pará, involved a qualified homicide and occurred in Altamira in 2012, and are heavily impacted by the construction of Belo Monte hydroelectric dam. I think you might have heard of it. And this construction caused significant social, cultural, and environmental disruptions for indigenous communities in the region. The case involves individuals from the Kayapó and Munduruku communities and is crucial for understanding the current state of indigenous legal treatment. The author was caught for homicide of another individual and was subject to a complex legal process, which included the demand of an anthropological study to assess his integration with non-indigenous society. And during the first hearing in 2014, 2 years after, the defense requested an anthropological study to assess the author's integration with non-indigenous society, which was approved but never conducted. This study aimed at determining his level of understanding Brazilian laws and his cultural background. The trial was scheduled for 2020, but then was postponed to 2022 due to the lack of anthropological report and the COVID pandemic. Later on, the defense and the public prosecutor elaborated some questions with different strategies for them to make the anthropological study. And the defense questions focus on the author's cultural background, his community potential, internal punishment, and whether indigenous jurors should be included in the trial. On the other hand, the prosecution's questions were more focused on the author's cognitive ability to understand the illegality of his actions, which aligns with the broader legal perspective of indigenous people as possessing incomplete mental development. This insistence on determining the author's capacity through an anthropological lens reflects an ongoing assimilationist paradigm. And the prolonged delay and the lack of the required anthropological report underscore the systemic issues within the judicial process regarding indigenous defendants. And I want to highlight that in the case of indigenous peoples, assimilationism also has an additional dimension fundamental to its understanding, which is the original right to traditionally occupied lands. The influence of economic power on this issue reveals the core of the indigenous rights issue in Brazil today, the right to land. In this sense, by integrating indigenous persons, the aim is to weaken their original right to permanent possession of traditionally occupied lands. Being indigenous is deeply connected to the land and various territorialities. To be integrated or assimilated means to cease being indigenous, according to what Occidental and what white society understand as being indigenous. Traditional populations, when de-indianized or desindianizadas, in the original Portuguese, an expression by Eduardo Vieira de Castro, are transformed into mestiços or caboclos or bugres, and consequently become invisible. Indigenous land has had constitutional protection since the Constitution of 1934, the Brazilian Constitution. However, the land of mestiços, caboclos, or bugres is free to be taken. Assimilation pressures are evident in how the legal system treats indigenous defendants. The demand for integration and evaluation of cultural purity often undermine indigenous identities and legal traditions. This reflects a broader historical context of colonialism and the ongoing marginalization of indigenous people. As an example of how tied these subjects are to the right to land and indigenous rights, Bolsonaro's government published a provisional measure in the first day of the new government in January 2019, which established the Minister of Agriculture, Livestock and Supply as a competent body to conduct administrative process for demarcation of indigenous lands. In 2020, FUNAI introduced a regulation allowing land registration within pending demarcation territories, which further complicates the issue. This case collective demonstrates the persistent patterns of modernity and coloniality despite normative progress. Legal pluralism offers a critical orientation against the state monopoly on norm production, but the practical implementation often falls short due to deep-rooted colonial mindsets. In conclusion, this research sheds light on the ongoing struggles of indigenous communities in Brazil, emphasizing the need for legal reforms that respect and integrate indigenous legal traditions. And thank you for your attention.
Thank you for your exposition, Victoria. Please, as we are short time to continue with Tugna. Sorry, and for me it's not so familiar your name. Tuyara Tumusoa, please, it's your turn. So at the end of the session, we have a space for questions and answers.
Thank you. Je vais présenter en français. Bonjour à toutes et à tous. Je m'appelle, comme on m'a déjà présenté, Tuyara Tumusoa. Et aujourd'hui, je voudrais vous partager quelques résultats de ma thèse de doctorat que j'avais soutenue en 2023 et qui a été consacrée à l'étude de l'identité autochtone des peuples autochtones en droit russe, et notamment au cas de la République Sakha-Yakoutie, qui est l'un des sujets de la Fédération de Russie, d'où je viens. Et dans le cadre de ma thèse, j'avais étudié tout d'abord la jurisprudence russe concernant les droits des peuples autochtones. Et l'un des résultats de cette analyse a été que l'approche dominante des tribunaux de droit commun a été plutôt restrictif et formel envers les droits des peuples autochtones. Notamment, j'avais étudié aussi la justice constitutionnelle, la jurisprudence de la Cour constitutionnelle. Et aujourd'hui, je voudrais plus particulièrement m'arrêter sur cette jurisprudence. Parce que, en fait, il s'est avéré que la pratique de la Cour constitutionnelle, elle a proposé, en fait, des solutions plutôt alternatives par rapport à la jurisprudence des droits, des tribunaux de droit commun. Il faut souligner tout d'abord que si on regarde la jurisprudence de la Cour constitutionnelle en général, elle est assez limitée concernant les droits des peuples autochtones, mais ce n'est que récemment, en 2019, que la Cour constitutionnelle s'est prononcée pour la première fois sur la question autochtone, notamment dans l'arrêt Gennady Shukin, et 2 ans plus tard, en 2021, dans l'arrêt Andrei Danilov. Donc, je vais d'abord commencer par présenter l'arrêt Shukin, par le détailler. Donc, cette décision, elle concernait notamment le droit à la chasse traditionnelle des peuples autochtones. Et la plainte concernait l'article 19 de la loi fédérale sur la chasse, qui limitait le droit de chasse aux individus détenteurs de permis de chasse et excluait ceux incapables de chasser pour des raisons de santé ou d'âge. Donc, Gennady Shukin, c'est le requérant et le représentant des peuples Dolgan. Il est aussi le membre et le chef de la communauté ethnique des Dolganes de Krasnoïarsk. Il a été déclaré coupable d'incitation à la chasse illégale commise à un groupe selon une entente préalable par la décision du tribunal régional du Kraï de Krasnoïarsk en 2018. Donc, en effet, en tant que chef de la tribu, Gennady Shukin a donné à chaque membre de sa communauté la permission de chasser 8 rennes sans demande d'autorisation. Il a délégué également le droit de chasse à quelques chasseurs de la communauté et il a pris de décision de multiplier le quota d'animaux chassés établi par le gouvernement par le nombre de membres de la tribu. Donc, dans son raisonnement qu'il a présenté devant le tribunal, l'accusé a justifié ses actes par la nécessité de fournir un soutien aux membres de la communauté qui ne pouvaient pas exercer la chasse, soit en raison de leur âge, soit en raison de leur santé, soit en raison de partage traditionnel des activités. Donc, avec les chasseurs délégués, ils ont abattu en tout 217 rennes sauvages et ont été tous condamnés. Donc, le tribunal de première instance a fondé sa décision sur les dispositions de l'article 19 de la loi fédérale sur la chasse, selon lesquelles les chasseurs autochtones n'ont le droit de pratiquer la chasse traditionnelle que dans la limite prévue pour le chasseur lui-même et n'ont pas le droit de recevoir de délégation de la part des autres membres de la communauté. Donc, en 2019, Shukin a contesté cette décision devant la Cour constitutionnelle de la Fédération de Russie qui, ayant examiné cette affaire, a formulé une série de positions juridiques assez importantes pour les peuples autochtones et qui sont plutôt favorables envers les autochtones. Donc, tout d'abord, la Cour constitutionnelle a déterminé un régime juridique spécial pour la chasse traditionnelle qui est destiné à garantir le mode de vie traditionnel et la pratique des activités économiques traditionnelles des peuples autochtones. Deuxièmement, selon la Cour constitutionnelle, le mode de vie traditionnel des autochtones supposait l'exploitation des ressources naturelles, notamment la chasse, qui était une base de leur existence et de leur survie. Et enfin, la Cour a reconnu les droits des communautés autochtones peu nombreuses de déterminer la méthode et la mise en œuvre de l'exploitation et de la vente des ressources de la chasse, de désigner des personnes qui peuvent réaliser la chasse ou la pêche au sein de la communauté, ainsi que de définir la quantité de prise dans les limites qui sont attribuables à chaque membre de la communauté. Donc, même si en fait la Cour elle n'a pas reconnu la disposition juridique contestée comme étant pas conforme à la Constitution, ces positions juridiques qu'elle a formulées, elles permettent quand même aux peuples autochtones de mieux profiter de ces droits. Je vais maintenant passer à l'arrêt Danilov, qui concernait également le droit à la chasse, mais la situation était un peu différente. Donc, Andrei Danilov, c'est un représentant des peuples samis qui a été refusé le droit à la chasse traditionnelle parce qu'il résidait en dehors du territoire traditionnel, il résidait dans une ville et il menait une activité non traditionnelle. Donc, Danilov, il s'est adressé d'abord au ministère des Ressources naturelles et de l'écologie de sa région pour lui permettre de chasser selon les pratiques traditionnelles du peuple sami. Donc, le ministère lui a refusé en arguant que Danilov ne prouvait pas son appartenance à un peuple autochtone et que la chasse n'était pas essentielle à sa subsistance. Donc, les tribunaux ont également soutenu cette décision, soulignant que Danilov résidait dans une ville, il avait un emploi stable et un revenu fixe. Donc, ce qui ne correspondait pas au mode de vie traditionnel des peuples autochtones tel que défini par la loi. Danilov a alors porté l'affaire devant la Cour constitutionnelle en affirmant que les lois en question violaient la Constitution et ne permettait pas à un membre d'un peuple autochtone vivant en dehors des lieux traditionnels de chasser selon les pratiques de son peuple. Donc, il a contesté notamment la loi fédérale sur la chasse et la loi fédérale sur les garanties des droits des peuples autochtones de la Fédération de Russie. Donc, cette fois-ci, la Cour n'a pas reconnu, comme dans l'arrêt Shukin, les dispositions juridiques contestées comme n'étant pas conformes à la Constitution, mais a encore formulé quelques positions juridiques. Notamment, la Cour a élargi l'interprétation de l'activité économique traditionnelle et a inclus des activités comme l'artisanat et l'art populaire dans les activités traditionnelles qui ont été pratiquées par Danilov. Elle a aussi souligné l'importance pour les peuples autochtones de maintenir un lien avec leurs territoires ancestraux et a reconnu que l'auto-identification et le besoin de préserver les traditions sont essentiels, même pour les représentants des peuples autochtones qui vivent en dehors des territoires traditionnels et qui ont perdu pour une raison ou une autre les liens avec leur peuple ou avec leur mode de vie traditionnel. Donc, ces deux décisions, Shukin et Danilov, ont une importance majeure dans la jurisprudence russe, dans le domaine de la protection des droits des peuples autochtones, car elles proposent des solutions alternatives de l'interprétation des droits des autochtones et démontrent une reconnaissance accrue des peuples autochtones et de leur autonomie. Dans ces deux décisions, la Cour constitutionnelle s'appuie sur des principes d'égalité et de justice et prend en compte les normes internationales pour ces interprétations, ce qui confère à ces décisions une force contraignante qui peut influencer la législation et la pratique judiciaire. Il faut aussi reconnaître que le recours constitutionnel est un outil important et crucial pour les peuples autochtones de la Russie de défendre leurs droits et intérêts aujourd'hui. Mais en même temps, il ne faut pas oublier le contexte politique actuel qui est marqué par la guerre en Ukraine et un environnement qui est peu propice au développement des droits de l'homme aujourd'hui et qui pourrait limiter l'impact de ces décisions. Donc, il faut remarquer que la Cour constitutionnelle aujourd'hui, elle doit naviguer entre les contraintes politico-juridiques tout en essayant de protéger les droits des peuples autochtones. Merci.
Okay, thank you. Thank you for the presentation. So it's the turn of Mariana, please. We know that you have another session as well. Please, I will give you 20 minutes to present.
Thank you, Madam Chair. Just a second so that I can share my screen. Okay. Yes, thank you. Actually, I was in the other session and then I left. So I'm here until the end, so no problem. It's a great pleasure for me to be here discussing this topic that lies in the intersection between law and anthropology, which was a work that developed while I was in the transition between the Max Planck Institute and the Federal University of Pará. The topic that I want to address today is the multiple roles of socio-anthropological expert evidence in indigenous land claims based on the decision of the Inter-American Court of Human Rights in the case Shukuru people. So this research was recently published in the Anthropological Forum, and It's an open access article, so if you want to know more about my work or about the research that I'm presenting today, you can check it on the website of Routledge. I have divided this presentation in 3 parts. I will start with a brief introduction of the case before the Inter-American Court. Then I'll move on to analyze expert evidence on the domestic Brazilian level. In a third step, I will move to analyze the expert evidence presented by Brazilian anthropologists before the Inter-American Court of Human Rights. And finally, I will conclude with some final remarks. As many of you might know, if you are familiar with the Inter-American system, this is not the first decision on indigenous lands, on indigenous peoples, or even concerning any aspect of indigenous ways of life. So why the Chukuru case? Why I have chosen this case route? And it's not because I'm Brazilian. This case has a special relevance because it touches upon the effectiveness of the right to property, Article 21 of the American Convention, which the court has been dealing with since 2001, since the Avastigny case more concretely. It started before, but Avastigny is the first landmark. And in this case with Brazil, the court reaches another level in that starts really to engage with the questions of effectiveness of indigenous land rights. So in the Chukuru case, the problem was the non-removal of non-indigenous individuals from the Chukuru people territory, which is a thing that's not only an issue for the Chukuru people in Brazil, actually is a thing that spreads all over the world in many countries for many indigenous peoples. So it's really important that the Inter-American Court has taken a stock on this topic. The added value is that in this case, it consolidated the understanding of indigenous lands as a place where indigenous people have the residency and holistically develop their life, highlighting that states must protect it. So this is an interdisciplinary notion of indigenous land that the court has been adopted in a long time, but that in the Chukuru case, it became more concrete. In light of that, I asked what was the role of the expert evidence submitted by cultural anthropologists in the Chukuru land claims. And to answer that, after I analyzed the Brazilian legal framework and explained a bit how the evidence was elaborated on the domestic level, I moved to the Inter-American level. Here, I will focus on the way that anthropologists, cultural anthropologists, have produced the expert report in the Chukuru land claims in Brazil. So if we are discussing the expert evidence used to protect a specific indigenous land, we have to understand the domestic context of it. And so the definition of indigenous land in Brazil. In Brazil, as probably my colleague has previously explained in the first presentation, which I missed, I just got the conclusions. We have like a beautiful legal framework on indigenous peoples and on indigenous land rights, which was many times praised by the special rapporteurs on the rights of indigenous peoples in their visits to Brazil. Mr. James Anaya and Ms. Victoria Tauli Corpus, both of them praised the Brazilian system because we have a constitutional protection of indigenous land, which is something that is not so usual in Latin America. So Article 231 of the Brazilian Constitution says that indigenous lands are those on which they live on a permanent basis, those used for their productive activities, those indispensable to the preservation of the environmental resources necessary for the well-being and for their physical and cultural reproduction, according to the habits, customs, and traditions. In paragraph 2, the Constitution stipulates that the lands traditionally occupied by indigenous peoples are intended to their permanent possession. So in a way, possession is equivalent to property, and this has to be recognized by the state through a process that we call, and that we have in many Latin American countries, that is the demarcation procedure. In Brazil, this is a legal administrative task informed by an interdisciplinary report that is coordinated by an anthropologist. In the Chucuru case, the coordinator was Professor Dr. Vânia Fialho, who was present also in the judgment before the Inter-American Court. In the report that Professor Fialho produced for the Brazilian authorities to recognize the Chucuru land, colonialism was an issue. And here I want to highlight two different ways in which colonialism was present in her report. First, we have to understand colonialism here in the way that I'm saying, as the denial or invisibilization of the existence of specific subjects to exercise control over their geographical habitat. In the Chucuru case, this was done in at least two ways. First, by one of Ms. Fialho's colleagues, that was an agronomist, while they were there as a team to demarcate the Chucuru land, he denied putting in the geographical map that they have to submit to the Brazilian authorities the presence of non-indigenous persons in this area. So by that time, Fialho identified more than 260 incidental properties in the Chucuru territory. So when you see, since that time, since 1993, I think that was the year of the elaboration of the report, there was a strong presence of non-indigenous persons. And this was more or less tried to be hidden from the Brazilian authorities in the original report. Another problem that the work of Vânia Fialho experienced was that by that time, by the time of the elaboration of this report, the beginning of the 90s, was still kind of a rest of indigenous policies in Brazil that denied the existence of indigenous peoples in Brazil's northeast coast. So they basically say that we still have indigenous peoples in the Amazon on this side, on the north, but we don't have in the northeast coast. And this was not only a state policy, was also a position defended in the scholarship at the academia. So it was a big issue for her to develop a report and go against those kind of assumptions that surrounded the Chucuru case. The Chucuru people, by that time, this assumption that they were not there was because since the first, when we go back, the historical legislation on indigenous peoples in Brazil, so since 1830, we see that there was a progressive land grabbing occurring in the country. So the Chucuru people that stayed in their original lands, they were threatened by the local elites who wanted their lands and who wanted them legally speaking also. So many of them were forced to move to other regions or to stay there and deny that they were indigenous so that they don't suffer threats by the local elite. And this was something that Fialho addressed in her work. And this is why her work is identified as falling under what we call ethnology of losses and cultural absences, which is a scholarship developed by João Pacheco de Oliveira, who is one of the big names of anthropology in Brazil. But Fialho was also a pioneer in stating and putting in words the Chucuru people in the northeast coast of Brazil as falling under this category, this innovation in the way that indigeneity is understood in Brazil. She mentioned also, and this is important to know, that this conflict between indigenous and non-indigenous peoples in the Chucuru people, this was something that kind of helped, not helped, but in a way supported the idea of a Chucuru identity. So conflict was understood in a new way in the process of territorialization of the Chucuru people. Fialho's report at the end had a value of recognizing, of anthropological, of academically recognizing the Chucuru people and submitting this recognition to the state, an authority that was respected for both sides. So it has a symbolic value. To understand that, we have to really stop there and move to the Inter-American Court, to the Inter-American level, where expert evidence was produced by an anthropologist who had never done fieldwork with the Chucuru people. So the expert evidence on that level worked in a different way. There we had this anthropologist, Professor Christian Teófilo, who was indicated by the state and had never done fieldwork with the Chucuru people, and Professor Vânia Fialho, who was on the other side as representative of the victims. And she was the one who has the expertise, who has the fieldwork and the contacts with the Chucuru people. And then as from the point of view of cultural anthropology, we wonder, okay, is Teófilo then really an expert? Is he in the position to produce a report to the Inter-American Court, since he has no direct experience with the Chucuru people? And according to the rules of procedure of the Inter-American Court, yes, this is possible. Why? Because on the Inter-American system, on the Inter-American level, we have a different understanding of what is expert evidence, what is an expert witness. In this case, it's defined in the court's rules of procedures, and it refers to the person whom possessing particular scientific, artistic, technical, or practical knowledge or experience.
Espagnol? Oh, putain, casse-les-couilles.
Someone has the mic open. Okay. So we have this kind of dichotomy between being an anthropologist on the domestic level, being the expert on the domestic level, who was Vânia Fialho, and Christian Teófilo, who appeared as an expert on the Inter-American level. And here I have to say that his testimony had actually a more legal approach, a more legal tone than an anthropological one, which was his actually his academic background. So his testimony, as defined in the proceedings, was about the Brazilian legal framework on indigenous land rights, the procedure regarding the demarcation of lands, the relationship between indigenous peoples and their occupied lands, and the relevance of cultural aspects for the territory. So as you can see here, there are actually not so many anthropological grounded aspects in his testimony. It was more a legal one. What can also lead to the question, okay, so why was he chosen to declare about a field, about something that was out of his expertise? Well, I don't know. I don't have an answer for that, but it's something that happens, that can happen in the Inter-American system. At the end, what happened? The Inter-American Court of Human Rights does not refer to Teófilo's expert report in the judgment. So why is that? It was also a question that I asked in this paper. And after analyzing not only the written report, but also the narrative testimony and the cross-examination that Teófilo suffered on the inter-American level, I conclude that the problem there was that he didn't have this field experience with the Shukuru people that was so much needed for the judgment, that was dealing with technical issues, intrusion in indigenous land, the presence of non-indigenous peoples in this land, how big was the land? He could not answer those questions. So, and this is why in one of the moments that he was receiving a lot of questions that he could not answer, he said finally, I'm not an expert on the Shukuru people. And probably this is why at the end the court did not quote him. And this is a big issue in the inter-American system. I'm moving to the conclusions. Why is it a big issue? Because the inter-American system follows the principle of sana critica. That means if something is important, if an evidence is important for this specific case, it's going to be in the footnotes of the decision. And this is not the case. So you can probably think, okay, so expert evidence had no role at all in this process. And then again, it was for me something surprising to discover that no, that when we think, okay, there is no role for expert evidence, we have to look at what Lawrence Rose calls the secondary effects of expert testimony. In this case, I saw that the court used it indirectly, implicitly, not mentioned it, some evidence that was produced for another case before it. That was the case Garifuna against Honduras. In this case, there was really a very detailed declaration by the Chilean lawyer Jose Ailin on the presence of non-indigenous peoples in the Garifuna territory. And this more or less explains the dynamics that were happening also in the Shukuru case. So in a way, there is this really anthropologically grounded knowledge that's present in the Shukuru case, not because the testimony of the Brazilian anthropologists, but because the historical work of the inter-American system with indigenous peoples' issues. So to that, I conclude that anthropological intervention, and here I'm quoting a Brazilian lawyer that's really famous for her work with indigenous peoples, Ms. Deborah Duprat. She says that anthropological intervention is a critical step in the process of indigenous peoples' self-determination. So we have to have this dialogue between law and cultural anthropology if we want to advance indigenous peoples' land rights. Thank you very much for your attention, and I'm looking forward for your questions. Thank you.
Thank you, Mariana. We really appreciate that you could make it in the time that we fixed. So at this moment, I want to let Sarah to give an overview of the different topics that we have heard this morning. Please, Sarah.
Yes, I want to start to thank you for your very insightful and rich pieces. So it's quite difficult to sort of summarize and comment on them, and that all of that in 50 minutes. But I'll give it a try. I'll try to frame it in terms of questions rather, and then open, so that we have enough time for the audience also to then ask questions. I also wanted to say that I'm not very familiar with the Brazilian and Russian system, which again makes it even more interesting for me to have read those pieces. So I want to start like I'm like with your piece, Victoria. I'm doing like some highlights, picking some pieces out of the paper, and then asking you some questions. So I think obviously in terms of procedural law and in a criminal proceeding, the question of near between Eden is really, I think, one of the like really crucial points when we think about the interrelation and complementarity of legal systems, the state's legal system and the indigenous legal system. And then obviously, and this relates obviously to that, the subsidiarity of state jurisdiction and indigenous jurisdictions in crimes and relevant acts on the territory when two people from the indigenous communities are involved. So what I was thinking, and this is, I'm already in the area of the questions, when you think about subsidiarity, do we think it in terms of material? Like, is it about the crimes? Is it when we think about procedurally, when we think about the different stages of criminal proceedings? Is it about already what's happening in terms of when we are in the investigative stages? So what is happening when they find out that an indigenous person is involved or not? Also, and I think this relates because I'm having an international criminal law background, and when you think about the ICC's complementarity principle, there it's very interesting because yes, you have the ICC can claim jurisdiction if there isn't any prosecution. This is quite similar to your cases, but it also can claim jurisdiction if there are prosecution, but they are unwilling and unable to do like genuine prosecution and investigation. And that I think is very interesting in relation to state law, where indigenous communities are suppressed, like oppressed, where especially in the criminal legal systems, there are obviously racist structures going on. And if that plays out in these sort of criminal proceedings, how does that affect the complementarity or subsidiarity between those two legal systems? That is one question. And then already being in the area of international criminal law, how does that relate if there are investigation on the international level? If you think, especially if you think about indigenous crimes against indigenous people, access to land and so forth, it's about, obviously you are often in the area of international criminal law with crimes against humanity and so forth, especially if you think about also the environment and so, and state policy. So I think this is also something, I'm sure there is a lot of research on this already, but I think this is also something really interesting for me, at least, to think how that complementarity also goes on the transnational and international axis. And this is also, I think, especially when we look at what's happening to indigenous communities, what about corporations? Because we were talking about natural people, but not about legal personalities. And so it's really, I mean, it's, yeah, I think you have to, maybe you have already some answers, and it would be interesting, and this would be rather the leg of referenda. If you think about, and this comes from the European human rights system, there is some sort of extraterritorial jurisdiction in very harmful human rights violation cases. So what about an inverse extraterritorial jurisdiction in cases where Western corporation coming in, because or a special sort of type of jurisdiction when corporate actors are involved? So this is for your piece. And for you, the second one, obviously for me, really the Russian system is a black box in a way, and I think I'm not the only one. And for me, it would be really interesting to see, because you were saying that that it's very important for these sort of the push towards the protection of indigenous rights through the jurisprudence of the Constitutional Court. To refer to and integrate international law. So for me, it would be interesting how international law is integrated into the Russian legal system. And also, I think what we were saying, especially in the Chuking case, for me, it was interesting to see how they pushed the tailors behind the hunting restriction, right? They used the common, like the administrative law, and they're saying, okay, we have these restrictions in order to permit indigenous communities to continue their indigenous cultural traditional lives and in times like that, resources maybe even. And if that is the reasoning, that would be for me also very interesting to hear a little bit more about it. And then, and this is a political question, what do you think about strategic litigation? If like representative of indigenous people, communities see that there is this jurisprudence going on, shouldn't they bring more cases in order to push that, to take on this momentum at the Russian Constitutional Court? And then this is a little bit on the dark side, and if you don't want to answer it, that's fine as well. Again, I'm not very familiar with the Russian Ukrainian context in detail, but is there also a danger of instrumentalization of indigenous rights in this context? Or even not only this context, but in the Russian Federation in general. That is for you. And then Mariana, I think this is also very, very, very interesting for me, because I think when we think about decolonizing the law, most of the people think about decolonizing the material, the substantive side of the law. And I think procedural laws are often neglected, and wrongly so, as your presentation and your piece, which I really enjoyed reading, shows. For me, and also when you think about this battle of experts, and also whenever the law, and especially also international law, does that as well, because it's Western. I mean, the international legal system stems from the European, Eurocentric tradition during colonial times. So it's reflected in how the system works, how the norms, the nature of the norms are. So for me, it's interesting, but because it's always claiming to be this neutral. So whenever you hear this expert witness, and I think it's reflected in the way the court, the Inter-American Court of Human Rights, say the expert witness is knowledge and not so much based in the communities. It's expertise. It's very technical again, very technocratic. And in that, and it's the way these norms work. And I would like to know whether in that you see in the same logic, how could you decolonize that? How could you decolonize the way we understand what is an expert, and how you see that in terms of strategies as well, like advocacy before the court, before these experts, before the judges. You're talking about training, and we just in the last session we heard about different research methodologies, and I think there's an interrelation between those two, and that could be training, it could be guidelines. If you were talking about the rule of procedure that is typical for all these international adjudicated bodies, so it would be interesting to come up with these sort of guidelines maybe, and that could also come out of the international human rights system, that could come out of the communities themselves. I was wondering what you think about that. And also, again, in terms of what is the function of Western colonial, in terms of colonial continuity, procedural law, when we think about that if we keep on this neutrality and this expert witness, isn't it a repetition of the state's law understanding of land? Because when we only have this expert witness on the international level, which is mostly the last resort in a way, and they are just not here listening to the communities, then it is a repetition of the material understanding of what land and property and access to land and land rights are in the context of the post-colonial state, that is still, as you saying yourself, very much influenced. I mean, the state system is a liberal idea in a way. And so it's a repetition through international procedural law of what is said, and it consolidates this system. So what are your thoughts on this? And finally, that would be also a little bit of a general question, because there is, I think, a project at the Max Planck Institute for Private Law in Hamburg on comparative decolonial law project. Maybe you've heard about it, I think, because they're starting to investigate a little bit on procedural law. That would be also something, I don't know if you're already involved or not. Yes, so far from my side, I think, for now.
So thank you, Sarah, for your appreciation. So we let Victoria, please, if you need to add to those words of Sarah.
No, okay, I can go. Okay, so about the subsidiary question, I think it's both procedure and material. Like they act in a subsidiary manner, but it will depend on the case. For example, the first case, the Basilio case from 1986, and the Nilsson case from 2012. There was no judgment of merit, so to avoid the non-bis in idem. But in the first case, it was only for the non-bis in idem, from the non-bis in idem principle. But the Nilsson case, which occurred after the Constitution, after the ILO Convention, and after the Statute of the Indian in Brazil, they used these laws to formulate the argument to not judging the merit of the procedure. And the third case was the jury of Roraima case was a subsidiary procedure case, because it still acted in a logic of state in state logic, because it uses the same instruments that we use in a normal procedure in the common justice to judge indigenous individuals. The only difference was that it was only only indigenous jurors, and that is the critic, because it has no evaluation of another logics or another visions of how to structure the law and how to structure the state and the penalties. So they were convicted, and there is another problem, because in Brazil we have no precise data of how many indigenous people have in prison. And yeah, because once they get there, they kind of lose its identity and they just become numbers. And so we have no precise manner to address these issues, since we don't have a data on how many indigenous are there, what crimes they are committing, and why are they there. And there are some researchers that have seen that stipulates that most of the many of these indigenous are in prison because of violent crimes. As Altamira, Altamira is a city in Brazil that is in this region. There was the Belo Monte, there was the construction of the Belo Monte Dam, and from this construction dislocated and expelled a lot of indigenous people from the territory, and this caused a mass of people to go to Altamira, and it was a city without infrastructure, and unfortunately the rate of crimes have gone up. And it's like one of the most violent cities in Brazil, I guess, and it's due to this loss of identity and loss of the territories in Brazil. And so yeah, there's this whole other problem, that is when indigenous people get to prison after they face these complex procedures, and there is this problem also with the anthropological reviews, that they are still, for example, in the last case, the defendant and the defense and the public prosecutor, they elaborated some questions, and as I've said, the public ministry, they focus on their ability to understand the laws, and it perpetuates this understanding that indigenous people doesn't understand the laws. and it's still in a state of logic and a logic of penalty, and it clearly doesn't respect another visions of the world. And for comparison with the international law, I won't be able to answer because it's not the scope of my research. But it's a very interesting question, and I really like to delve more into this question. That's it. Thank you.
Permettez-moi de répondre en français parce que en anglais, malheureusement, je ne pourrais pas m'exprimer si bien qu'en français. Concernant la première question de la place du droit international dans le droit russe, déjà, la constitution de la Fédération de Russie, selon l'article 69, elle garantit les droits des peuples autochtones plus nombreux, conformément aux principes et normes du droit international et aux traités internationaux. Mais le problème, c'est que aucun traité et document international n'a été ratifié par la Russie jusqu'à aujourd'hui, parce que la Russie, son argument principal, c'est que la situation de la Russie concernant les peuples autochtones, elle est un peu particulière, et même la définition des peuples autochtones, elle est comment dire, elle n'est pas conforme au principe du droit international, parce que les peuples autochtones peu nombreux, donc qui sont protégés par le droit russe, ce sont les communautés ethniques dont le nombre ne dépasse pas 50 000 personnes. Donc il y a des peuples autochtones dont le nombre dépasse ce nombre, mais ils ne sont pas protégés par le droit parce qu'ils ne sont pas conformes à ces critères du droit russe. Donc, c'est notamment aussi un grand problème qui existe. Donc, même si la Constitution, en fait, elle dit que, en fait, la protection des droits des peuples autochtones doit être conforme au principe du droit international, elle n'est pas comme ça de fait, de facto. Deuxième question concernant les limites de chasse, c'est ça? Oui. Oui, en fait, les limites de chasse, ils varient en fonction de chaque région. Chaque sujet de la Fédération de Russie, en fait, elle définit ses normes de chasse et de pêche traditionnelles pour les peuples autochtones. Donc, pour le cas de Shukin, par exemple, c'était 8 rennes par personne. Et concernant la troisième question, je crois que je n'ai pas bien compris
la troisième. Comme s'il y a des avocats des droits de l'humain ou des droits des gens autochtones, si vous les, comment dire, donnez l'advice. Si vous le conseillez de faire d'aller au tribunal et d'initier une action de justice ou pour avancer cette jurisprudence bénéficiaire.
Oui. D'accord, merci. Le conseil que je donnerais, c'est de se fonder surtout sur les approches plutôt anthropologiques et sociologiques, parce que souvent les avocats des peuples autochtones qui les représentent, en fait, ils s'appuient seulement sur les critères formels, purement formels du droit, alors que en fait la réalité sociologique et anthropologique des communautés autochtones en Russie, elle est beaucoup plus variée et compliquée et complexe en fait. Et en fait, c'est ça qui empêche de protéger leurs droits.
I'm
Should
very
I go?
sorry because I can understand French, so I was checking the translation channel. Sorry, but I was trying to follow the conversation, so I won't take the time of Mariana. Please, Mariana, can you tell us a bit more about your presentation, please?
Thank you, Amelia. And thank you, Sarah, for the inspiring question. I was really very reflective about what you said at the end about how to decolonize the concept of expert witness. And to answer that, I think the first step would be to actually agree that expert witness is a colonial concept, which I think is not at least on the inter-American level. The definition that the court has in the rules of procedure actually is a very broad one. That was the problem in this specific case. But to solve that, the problem is not to change the concept, but change the way not only the anthropologists use it, but also that the parties of the proceedings, of the complaint, how they see the expert witness and how they frame it. The problem actually also related to expert witness is a thing that you have in the European system of human rights, that the Court of Human Rights does not rely a lot on expert evidence as the Inter-American Court does. So I think in a way we have a more progressive system than the one that you have through the European Court of Human Rights. And here the thing is, we have this broad definition. What I say in my paper, and I'm trying to say here, is that we have to understand how to use it. And this is really a difficult part. And I'm saying this not only in the case of indigenous peoples, but more generally when we advocate before the Inter-American Court. We don't have a lot of expertise about how to use expert evidence in the Inter-American system. It's something that we, as lawyers, we have to understand better, because we don't see this, for example, at law school. So we don't know how to do this in practice. And on the other side, the anthropologists, they don't have the special training that is needed to do the expert witnessing on the Inter-American level. So for me, it's not a problem with the concept. I don't have problem with the concept. I think the definition of the Inter-American Court is really advanced in the sense that it also includes the experience. It's not only about technical knowledge, it's about having the experience in the specific topic. So in a way, it's very progressive. The problem is we, as parties, as lawyers, as representative of the victims, as a representative of the state, we don't know how to use it. And the anthropologists, they are not training to do this kind of expertise on the international level. If they are usually, they know how it works on the domestic level, not on the international one, which has specific requirements. So the problem for me is really the implementation. But I think it was a great question to clarify that expert witness is not a colonial concept, but we have to understand it, how to use it, let's say, in a post-colonial way. Thank you.
Thank you, Mariana. So in this moment, only we have 15 minutes to hear more of the question of the public who is in the room. As we are in the full day of decolonizing academia, probably you prefer to use your own language to express your questions. So I will ask the support the persons who are organizing the event in the room, so to help me to pass the question, because I cannot listen well from here, from well, I'm from Peru, but I am in the connection, but I cannot hear well in the room what is people saying. Please, we hear what's do you want to know more about the exposition?
Y una pregunta. Gracias, Amelia, por recordarnos que estamos en la decolonización de la academia, entonces yo voy a hablar español. Yo sé que Mariana habla también español, así que, bueno, confío en la traducción. Mariana, tú dices, yo no tengo problemas con la conceptualización del expertise. Sin embargo, eso dentro de las literaturas decoloniales y de las filosofías jurídicas es problemático. Como yo estoy en el lado de la filosofía jurídica, no de la antropología legal, me pregunto también a Amelia, a los que son más versados en estos temas, ¿cuáles serían entonces los procedimientos para mejorar estas tareas que tú mencionas entre la antropología legal y los abogados? Porque me parece que es una tarea importante. Pero como estamos hablando del expertise y de la experiencia, ¿cuáles para ustedes serían algunos pasos importantes en esa dirección? Eso.
Okay.
Amelia, ¿lograste escuchar? Sí.
Gracias.
Sí, parece que sí.
Sí, gracias, Carolina. Vamos a juntar las preguntas. Por favor, vi desde la pantalla que otras 2 personas también expresaron su interés.
We asked the question, okay, whatever. Thank you very much for everyone. It was very interesting and merci beaucoup pour parler du système en Russie. C'est très intéressant et puis on n'entend pas assez parler des peuples autochtones en Russie. In Canada, I'm also I'm doing a lot of stuff around chronology and Indigenous people. I'm also what they call Gladue report writer. So there are Gladue reports in Canada for Indigenous people who go in front of court. They have the right to get this report which speak about their life, but also an alternative to incarceration. So I'm also critical of these reports, but they are very interesting because they've been kind of institutionalized and funded, and they're supposed to be provided to all Indigenous people who are facing detention. They're supposed to receive these reports to make sure that their identity, their practices, and the community is taken into account. So my question would be for the presenter in Brazil. You're talking about these kind of anthropological reports. So I was wondering to what extent these reports are actually used in the Brazilian context, and in what step are they used? Because for us, they're really used at the sentencing process. They're not used at any other steps for now. So I was wondering if these reports are written and to what extent they are used.
Muchas gracias. Entonces, la tercera persona, por favor, que levantó la mano. ¿Hay una tercera persona?
Aquí.
Sí, por favor, lo escuchamos.
My question is more directed towards the idea of expert testimony in the Inter-American system. Has there been a trend towards, say, recognizing members of Indigenous communities as holders of expertise and expert information, perhaps elders in communities, rather than having the anthropologists act as a middleman, so to speak?
Bien, creo que, a ver, Mariana, por favor, siento que 2 preguntas han sido dirigidas a ti, por favor.
Thank you, Amelia. I think Carolina also included you in the first question, so you can also maybe say something about how to which are the steps regarding how to promote this training regarding expert witnessing. But I will start with the last question, which I think is the easiest one. No, there is no case law, no use in the Inter-American system of indigenous leaders, of indigenous voices as experts. I think this is something that you have in Canada, but we don't have this so far in the Inter-American system. Not that this is forbidden or that's not legal. You can do that, but no one has ever done that. Usually indigenous leaders or indigenous lawyers, they come as representatives of the victims, but not as experts. Regarding the other question, the second one that was about the use of expert evidence in the proceedings for recognizing indigenous land rights in Brazil, it's actually a fundamental piece of the procedure for recognizing the indigenous lands. So all of the procedures that we have has to have an interdisciplinary expert report coordinated by an anthropologist to move forward. So different from Canada, we start with an administrative procedure, and the recent trend is that those administrative procedures, they have been judicialized, that we call. So the private landowners, they try to make that this process, they take a longer time by taking to the courts and kind of saying that one of the requirements was not met, so it takes more years. Usually, I would say, like the Shukuru land took more than 30 years to be recognized, but it has to start with the anthropological report. So all of the procedures all over Brazil, they have it. It's I think it works in a different way because it's not a legal procedure, it's an administrative procedure that then is recognized at the end by the president, who declares a specific land as an indigenous land. And the first question was about that expert witness, expert evidence is a contested concept in some settings. And I see the problem with that. We have also this problem here in Brazil. And what I would say, how we solve it? We solve it by fostering interdisciplinary dialogue between the different disciplines, between lawyers and between cultural anthropologists. Here in Brazil, for example, we have the Declaration of Brasilia that was established in a common meeting between different persons with different backgrounds, also with representative of the state, in that they discussed the way that expert evidence has to be elaborated. And I think those meetings should also include the persons which are really addressed in those expert reports, should also include indigenous peoples, so that we can define the guidelines about how to produce it. But for that, the very first step is that we meet each other. And this is something that we have been doing at the Department of Law and Anthropology at the Max Planck for Social Anthropology in Halle, where we have really this encounter between lawyers and cultural anthropologists, so that we can debate expert evidence and we can really together do the basis for elaborating them. Thank you. I think that was all.
Antes de añadir un poquito a lo que ha dicho Mariana, porque fui aludida en una de las preguntas, en la primera pregunta, no sé si una de las dos ponentes de Victoria o Lara desea hacer alguna acotación, añadir algo más.
I just
Final words for the two speakers, please.
I just wanted to answer his question about the anthropological reports and the criminal procedure. It's a little different from the anthropological report that Mariana was saying, that was for a demarcation of indigenous land. Here in this procedure, they are elaborated after the judge asks for it, and the defense and the prosecution can elaborate some questions, but there are some problems as to find a qualified expert. It's very difficult because, as Marianne stated, it has to be someone that knows the community, that knows, at least knows the problems, or studies it, and it's not easy because Brazil is huge and there's a lot of different communities, and it's not something that judges are specifically concerned about. And well, these questions, they are used to formulate the relatory of the anthropological, the report, and they're used to formulate the sentence. So but it's not mandatory. So as it was stated by the resolution from 2019, so it's a quite new resolution, and unfortunately it's not mandatory, but once the judge asks for it, it has to be done. But as we have these problems of lack of experts, qualified experts, it gets delayed and delayed and delayed, as it was the case of one of the cases that I explained. So it's a very new, which indicates also that it's not every judge that will have knowledge of it. So in the criminal procedure code and the criminal code, there's nothing about indigenous rights in these procedures. So it's a new resolution from 2019, and many judges don't have knowledge, even the defense won't have knowledge of it. So it's not quite used, yeah.
Muchas gracias, Victoria. Bien, yo quisiera hacer una aproximación, tal vez no tan experta como Mariana, pero lo voy a decir desde mi propia experiencia y de lo que yo vivo como docente actual en la universidad aquí en Perú. De hecho, bueno, la pregunta estaba orientada a cómo hacer, digamos, cómo promover el uso de la antropología jurídica dentro de los propios procesos, cómo facilitar este encuentro entre antropólogos y abogados, ¿verdad? En un primer término, yo lo vería incluso desde un punto muy embrionario, que viene desde la propia formación jurídica de nosotros, los abogados. Y yo he visto que en los recientes años, muy pocos años, se está incorporando dentro de la malla curricular en estudios de derecho, antropología jurídica. Y eso podría decir que es un gran avance. Es un gran avance porque la formación que tenemos los abogados, no sé muy bien en Europa, pero al menos en Latinoamérica es muy legalista. Entonces, desde el punto de partida, desde esa cuestión de nacimiento, ¿no? Nosotros, de adquirir otras lógicas desde nuestra formación, desde nuestros primeros años, es muy importante. Ello nos orientará finalmente en un futuro, cuando asumamos algún cargo de responsabilidad, sea administrativo o judicial, a tener otra perspectiva del derecho. Eso es como punto 1. Punto 2, yo veo también un tema institucional. Un tema institucional desde la judicatura, desde los propios, digamos, ni siquiera desde la judicatura, desde todos los órganos que forman la constelación de la administración de justicia. ¿No? Estoy hablando desde quien persigue el delito, investiga el delito, desde ese momento tener consideraciones, una aproximación, ¿no? De que existen diferencias culturales. Desde la investigación es tan importante, ¿no? Estoy hablando tal vez en mi lógica están más los casos criminales, distinto a lo que estamos viendo con el tema de tierras y que están en la corte, en el sistema interamericano. Pero digamos, los casos criminales son además tan interesantes, digamos, en una lógica nacional, porque implican muchas veces, involucran el quebrar la libertad, el derecho a la libertad de las personas involucradas, muchas veces indígenas, obviamente. Entonces, el tema institucional, desde la investigación y todos los actos procesales a nivel del Poder Judicial, muy importante. Y todos los órganos, al menos que están también supervisando. Llámese Defensoría, ombudsman, los ombudsman que tenemos también, inclusive, todos que estén, digamos, con esa lógica. Y otra cuestión también bastante importante es el fortalecimiento, no sé, lo hablo desde la experiencia peruana, de los colegios de antropólogos, ¿no? Colegios profesionales de antropólogos, ¿no? Así como tenemos los colegios profesionales de abogados, los colegios profesionales de antropólogos. Revisar cómo es que hacen sus dictámenes, porque en el caso que nos indica Mariana, un antropólogo asume y hasta se puede decir que no es tan ético, porque no conoce la cultura, pero asume igualmente, ¿no? Y entrega una visión muy general del caso. Y es un caso de tanta importancia que obviamente relacionado a tierras, y todos en este salón sabemos que el tema de tierras es fundamental para la supervivencia de pueblos indígenas. Entonces, es una cuestión ética además, ¿no? Entonces, en ese punto, el trabajo junto con los colegios de antropólogos. Tenemos un dicho bien claro que tal vez es conocido, zapatero a sus zapatos. Entonces, son las personas que tienen que decir algo, pero incluso como antropólogos no pueden asumirse decir algo que no conocen, o sea, de la cultura que no conocen. Me pareció excelente y es algo que también iba a consultar y me ganó Sara cuando preguntaba esto, ¿no? De las técnicas, la decolonización en esa apreciación. Y eso también es un trabajo pendiente dentro de la antropología. Entonces, digamos, en maneras muy resumidas, ¿no? Desde la formación jurídica, que es muy importante, porque ese es el futuro, o sea, finalmente son quienes ocuparán, digamos, estos sillones decisorios, ¿no? En estos puestos en la administración de justicia. Entonces, desde ahí y luego el recuperar, ¿no? Esa institucionalidad o ganar espacio en la propia institucionalidad. En el caso peruano, si bien tenemos reglas a nivel solamente del Poder Judicial, ¿no? Cuando el caso ya está judicializado, en el que señalan la obligatoriedad de realizar estudios antropológicos o pericias antropológicas, los debe ordenar el juez. No en mucho, o en muy pocos casos se ordena. No. ¿Por qué? Porque hay un problema desde la entrada, que es el tema de la autoidentificación. Entonces, si no se identifica correctamente a la persona y la persona no se autoidentifica como indígena, en el proceso pasa desapercibido. Entonces, luego vemos cómo durante todo el proceso se transgreden sus derechos, ¿no? Y uno de ellos es contar con una pericia antropológica. Uno de ellos, porque en el proceso debería tener una serie de garantías. Podría ser, por ejemplo, contar con un intérprete en su lengua originaria, una cosa. Pero como pasa desapercibido, va. Y por ello es que no voy a generalizar, pero muchas veces llega hasta las instancias internacionales. Ya me cortan. Muchísimas gracias por su atención, por la participación de cada una de las ponentes. Para mí ha sido un placer conocerlas aquí, escucharlas, y también para cada uno de los asistentes y las preguntas. Hasta una nueva oportunidad. Adiós.
Thank you, Amelia. Thank you, everybody. See you. Bye.
Perdón,
Bye.
Amelia, por contarla, pero estamos un poco justo en el
No
horario.
te preocupes, hemos empezado tarde, no te preocupes.
Gracias.
Muchísimas gracias.
Gracias por todo.
Adiós.